Hey everybody, this is Matthew, and this video is going to be on the exclusive right to represent buyer agreement as it stands in the NVAR forms library. The video is being recorded on May 14th, 2019, and as we know, every 6 months or so, the associations do upgrade or update the agreements, so to make sure that what you're using is related to this, and if there's any changes, you're familiar with them. So the buyer rep agreement is something that's been around for a real long time since, well, when I got licensed 16, 17 years ago, and not everybody really used it. And then we had this regulatory change that said you shall sign a buyer agency agreement or a disclosure of representation prior to providing any advice or counsel, to showing properties, and to a whole number of other things. And so I want to address that this is a required document. This is what the Forms Committee has created to satisfy the statutory requirement of disclosure. Now, that's a few elements of this agreement. There are other elements of agreement that are in excess of the minimum required disclosure the state has provided that then protects the buyers and, well, in a lot of places, protects us as agents. So it is an essential form and it is a required form. And I know some agents just aren't comfortable getting their clients to sign this. I'm not sure why. You get them to sign listing agreements just fine, but this seems to be a bigger struggle. So let me say that we're not covering in this video all the mechanics and all the things you should have done prior to even meeting with your clients to start to build loyalty and understanding. I'm only focusing on the form itself and a couple talking points per paragraph. There are other classes we're going to do about how to meet a buyer and get them on board with you and have them work with you and etc. All those other things. So with that said, this is a required form. I know there are some exceptions that people have heard and manufactured even as to I don't need to get it signed because I'm not X. The exception that VREB issued in their memo a couple years ago was for those instances in which you're showing a property with the buyer not having the intent to purchase it. So if you're showing a potential seller comps or an investor who wants to see what else is in the market or upgrades, that's separate. You don't need an agreement for those things where the buyer doesn't have an intent to purchase a home. And I know, again, everybody seems to be looking for a way to weasel out of getting this done, and there isn't one. You have to get it done. So again, we're going to focus on the agreement. So starting at the top, this is the exclusive right to represent agreement. Of course, the date is the date. In our case, our fake buyers are Bobby and Bobby Buyer. And then our brokerage name goes there. Paragraph 1 is a statement. It is saying we, the consumers who will be signing this, the buyers, or establishing that Coldwell Banker Elite is going to be our broker of record. They're representing us. They have the authority to speak on our behalf, and we are agreeing to align ourselves with them to carry out our interests. Paragraph 2 is the buyer's rep, and this is an important paragraph. This is simply the buyer saying that they are not a party to any other buyer agency agreement. This helps us meet the requirements under Code of Ethics Article 16, in which we're explicitly instructed to ask parties if they're a part of an exclusive right to represent agreement. So this is an important element to remember, that the Code of Ethics requirement is only targeting when the buyer is subject to an agreement that says they can only work with a specific agent. This is not to protect other agents per se. This is to trigger a conversation with your buyer who says, well, we think we did sign something. You and I are then to encourage them to understand that either they need to get a release from the other broker, or that they may be subject to some type of financial penalties for working with you if they are still subject to the original agreement. If they are clear on all that and don't care and just want to go see homes, then fine, go show homes. You're not obligated to honor the other agreement. You and I are not parties to it, nor are we permitted to ask to see it, nor are we to be involved in any type of termination. We can't draft language. We can't give advice and counsel. We can't encourage the buyers to terminate. We can simply ask, are you subject to it? And if you are you aware there's penalties? And if you are and you still want to work with us, let's go see houses. Sign here. The buyer is also saying that they're going to let you, the buyer agent, know if they've seen any other properties with other agents or any new construction or visited any open houses that they can remember. This is simply so you get a handle on what they have and haven't seen. And so that if you go to a house and show it and they go, oh yeah, we came here already, that should trigger in the back of your mind that there may be some procuring cause issue where another agent showed the house. Now, remember, showing the house is not the end all be in procuring cause. Showing a property or the threshold rule does not say that that agent who showed it is subject to the commission. Not at all. Matter of fact, it's just one small element. But it is something you should have as a dialogue in your head about what to do next if the buyers have seen a house you're already showing. So again, this is to get the buyers to trigger a conversation with the buyers saying, have you seen other homes? Have you visited open houses? Have you talked to other agents? Are you subject to any agreements with them? Paragraph 3 is notices. This is a legal paragraph, or this is a paragraph about legal notices. So if we have to serve some type of termination agreement or legal proceedings or anything arising out of our representation of the clients, whatever information is in paragraph 3 is where we will file that. And it's just a good place to get your client's information, contact information, to make sure you have it correct. So please make sure this is complete. Empty lines are a problem. If I have the phone number and they don't have a home one, put NA. They don't want to give you the work number, put NA, and to put their cell phone number, that's fine. Just fill it out. Then, of course, your brokerage information should be the office that you work with. So let me do a quick pause here so I can fix my alignment. So then we have the addresses. Then termination. Now, termination is a funny paragraph. Let me start with, first of all, this agreement terminates at midnight or 11:59 p.m. and whatever date you've listed in the agreement. Now, if you're meeting your buyers for the first time and you've had a dialogue with them and you're sensing that they're just not on board with working with you forever, you don't have to be married to them for 6 months. I know a lot of buyer agents are like, look, I got a 6-month agreement. You may not want to work with them for 6 months. They are going to feel a little, of course, you ask somebody to sign a 6-month agreement. You're now instilling in their mind that, oh my gosh, I'm to be with these people for 6 months. That's a long-term commitment. I don't want to be in a long-term commitment. This may be agreement for 2 days. It may be just the weekend. Maybe it's 1 week or 2 weekends if they're just flying in to look at homes. But when you're in that first meeting, asking for 6 months is way too long in most cases. And it ties you to this agreement. Very often a buyer agent will come to me and go, how do I fire these buyers? They're always offering low offers even when I tell them not to. They're not listening to what I have to say. They're writing embarrassing agreements, whatever it is. They're treating me poorly. They're not respecting me. Well, the easiest way is to say, you know what, this terminates in 2 weeks. Just hang on for 2 weeks or ask them out of the agreement. And if that doesn't work, then in 2 weeks, you can terminate on your own without any damages to you. So I'm all for a shorter agreement, at the most 2 months. Remember, this agreement is only to get you to the contract. Once you're under contract, that agreement keeps going. That's your new agreement to work with them and be their agent on their behalf. There's paragraphs in the residential sales contract to establish that. So this doesn't have to carry you to closing. This carries you until they enter into a contract for a home. And then the termination agreement. I do put $1,500 in my buyer agency agreement in case they want to terminate early. And that's if they want to terminate early without reason. And so I tell the buyers, this agreement's for 1 weekend or 2 months. If for some reason you don't, after all the time that I've worked with you and all the stuff and services I've given you, if you feel like you just don't want to move forward anymore, you can terminate this agreement for $1,500 or $1,000 or $500 or nothing if you want to. That agreement is totally up to you, the agent, and what you put in there. So far, I've been using this buyer agency agreement for 15 years, and I've never had any buyer upset about the time frame I put in, the commission I put in, or the early termination fee. I think most of them just assume they've chosen you and they're going to work with you. And that's in case they wander off and start working with another agent who's incentivized them or whatever. All right, paragraph 5 is the broker duties. And this is really this is the disclosure part of who is representing them and what our requirements are. The paragraph here is a more layman's version of what's in the regulation for you and I in the Code of Ethics, what we're supposed to do. So we tell them first we're going to perform to the terms of this agreement. And the way I present that to my buyers is that this is an agreement between you and I to ensure that I'm doing the things and you can hold me accountable for the things I've told you I'm going to do. B is seeking property and price at the terms acceptable to the buyer. Mr. Buyer, Mrs. Buyer, we're going to be looking for homes in this price range and for this area. And I am not going to take you to homes that are more than what you feel comfortable paying for. I'm not going to take you to homes that don't meet your criteria. I'm only going to be searching for the homes that meet what you tell me to meet and what you're qualified for. This is going to help clarify that you're not going to be running all over the state for them, that, when they come up and you go, why didn't you show me this property? Well, because it's $100,000 more than you can afford. That's paragraph B is to give context for what your services are and to limit their expectations to what is reasonable and not far-fetched. Presenting to you in a timely manner all offers and counteroffers, Mr. and Mrs. Buyer. One of the things that I know a lot of buyers are looking for in an agent is timeliness. Anything I know, you're going to know in real time. If I get a counteroffer, an addendum, an agreement, anything, I'm going to forward it to you, and instead of a time to explain it and chat about it later, but you'll get it as quickly as I do, as quickly as possible. I'm going to disclose to you any material facts about the property that I know or anything I know about the transaction. So understand that I don't know everything. I'm not licensed to know everything, but whatever I do know, you'll know. I'm not holding anything back. I'll share it with you in real time and point out things I think may be of interest to you. I'm going to make sure we account in a timely manner for any money. So there is going to be a time, Mr. and Mrs. Buyer, where you're going to want to write an offer. And one of the elements of an offer is an escrow. This is the amount of money that you're providing to the seller to promise to perform, and they can hold you accountable for should you default, should you just walk away when you aren't capable to in the contract. That money very often gets held in our company's non-interest bearing escrow account or in the settlement attorney or account or whatever, and that we can only get that money back to you if you and the buyer, you and the seller agree, or the court orders us or whatever, but we're only going to ask for it when you go under contract. So this is a good point for you as the agent to kind of feel them out for whether or not they understand how escrow works, and that they are going to give money and what that means and how much and all the rest. Also, the next one, E, is I'm going to, after E, also, Mr. and Mrs. Buyer, you need to understand that I'm going to hold things you tell me in confidence. I'm not going to share your opinions about homes on feedback. I'm not going to share any confidential information on why you're purchasing, what you're qualified for, none of that. Everything you tell me is confidential, and I will hold it until you give me written consent to release that information or court orders me otherwise. You also understand that I'm going to use ordinary care rather, in the agreement, that I'm going to do everything I can in the law and regulations to treat you honestly and give you the best options that I can. If at some point I am representing a buyer who is also interested in the same property you are, you and the other buyer will be made aware that you're both interested. I won't violate any confidence. I won't tell them the details of what you're offering, and then we'll have a decision on whether or not you're comfortable with me moving forward representing you and another buyer. It doesn't happen very often at all, but it is letting you know I work with other buyers, and some of them may be interested in the same home I'm showing you. And at the top of this page on page 2, this is derived from Standard of Practice 113 and 115 of the Code of Ethics. Mr. and Mrs. Buyer, you need to understand that the offers that you're making to the seller are not confidential. Once I give it to the seller, I can't share the terms of it, but the seller and their representative can. What that means is it is perfectly lawful for the seller to take your offer and try to make other offers better. This is why I encourage you, Mr. and Mrs. Buyer, to make the best possible offer up front. If you want to play around and see if you can get it for less, that's fine, but you run the risk of the seller using that in the negotiations with other buyers. So I will write whatever you tell me to, so long as it's lawful. Just understand that in our marketplace, the sellers are realizing 97 to 98% of their asking price. So if we go any lower than that, you may be preparing the seller to simply improve other offers and not take yours seriously. Just letting you know, they're not bound by, they aren't being required to keep those terms confidential. Paragraph 6. Mr. and Mrs. Buyer, after all the stuff I laid out for you during our interview process and all the resources and tools I've shown you, we do ask for you to do something in return. And that is for the duration of this agreement that you're going to work with only me and my firm. And just like when you take a job, we establish that there's going to be compensation and we're going to get paid. This is how we get paid, is representing you and working with you. So all the weeks or months or days that I spend with you, that is time I cannot spend with other clients. And so I do not want to take that time and then not at some point be compensated for it. So we ask that you work with us and us alone. This also benefits you, Mr. and Mrs. Buyer, in that you don't want to have to re-explain or be re-interviewed with another agent, all of your interest, and then all the stuff that could fall through the cracks. So if you and I are a good team and partnership, it is best to have continuity and consistency in the agent who is showing you various properties, learning about your needs and your desires and your wants, and then doing the best we can to fill that so you don't have to keep going all through all this with another agent. And we're absolutely going to give you the best service out there. So Um, we are going to also ask you to comply with reasonable requests. So if I ask you for something like getting information to the lender or whatever, it is in your best interest, and getting it to me in a timely manner helps to show that you're acting in good faith in the contract and defend you from any legal accusations should there ever be, on a rare occasion, any type of lawsuit or liability issue questioned. Also in this paragraph, Mr. and Mrs. Buyer, I want to remind you that it is not lawful for you to take video or photos or live stream from the inside of someone's home without their written consent of the seller. And that if you do that, if you take this and you post it or you publish or you display it, you could be harming yourself. You could open yourself up to risk. You could open the seller up to liability or risk if somebody uses those photos to break into their home. And that you are holding us harmless. If you choose to do that, even though we've warned you against it, we're not going to be responsible for the outcome. If you do need to live stream or take video or photo, I need to get written consent from the seller, a listing agent, via at least email before you do that. And so again, I also want to advise you while we're talking about that, is that the seller may, and probably, we know that 33 to 50% of homes in a given market area have smart systems, smart security systems in there, video cameras, listening and audio devices. Please be careful, Mr. and Mrs. Buyer, when you go into a house, that you keep your conversations confidential, and that you write down the notes. I'll give you something to write with. You can write down your notes and we can discuss them when we're off the property. Those cameras and listening devices are now on the doorbells. They're in cameras on the front porch, around the house, inside the house on multiple levels. And it is best that you not exaggerate your response. If you think the house is bad and you want to make an offer on it at some point, you don't want to harm the seller by bad-mouthing their home and hurting your negotiations. If you think it's super good, you don't want to harm your own negotiation standpoint by seeming overly interested in the property. So keep your act together, act accordingly, know that you're probably being recorded in the home. The paragraph 7 is the paragraph that talks about what we're looking for. And some of you put very broad stuff like homes in Virginia. And you could be then asked, because remember, this is a contract, a personal services agreement is a contract. You could be asked to go down to Virginia Beach to show properties where you're not familiar with the forms, you're not a lockbox member, you're not an MLS member, you don't know their customs, and it can harm you and your client. Remember, Article 11 of the code requires us to be competent in what we do or disclose it to our client, like to make the decision whether they want to keep working with us. So I like a very simple phrase: residential property within 60 miles of the broker's office and within our MLS footprint. It doesn't mean it has to be in MLS, just within the footprint we serve. And 60 miles is still pretty far. And if they want to go further, you can amend this or go further. But if they make an accusation like, you didn't show me this property or you weren't available on this weekend to go show them a $110,000 house 2 hours away, well, then you can come back to this and go, I wasn't obligated to. Remember, this line is supposed to be limiting the scope of your responsibilities for liability purposes. Paragraph 8, this is the one that people tend to get riled up. So let me just run through how I present it. Mr. and Mrs. Buyer, understand that just like when you take on a job, you know what you're getting compensated, and that you typically would not go to work in your career or line of work for free. I don't either. My time has value. The training I have, the experiences I have, the resources I'm providing to you all have a value. In this case, I'm not charging you a retainer fee. Some brokers do, and they will ask for money up front to make sure that you work with them and keep them in this agreement. I've elected, as customary in our area, to get paid at closing, but I earn that money when we enter into a contract. I do a lot of work for you up front. I'm going to spend a lot of time with you visiting homes and giving you my expertise and advice, and then ask to get compensated for it when we close. My compensation is a minimum of 2% of the gross sales price, plus our firm has a $375 base commission fee. Now, the commission will often be more than 2%, to let you know, and very often the seller has offered an MLS to compensate me for those services on your behalf. However, there are cases and instances in which you may be looking at for sale by owners or military by owner, or a home and where the seller has offered very little money to the buyer agent for compensation just to get into MLS. In those cases, it may not honestly be worth, just like you going to your job, if you're offering you less than what they promised, it may not be worth your time to do and to take away from other clients and services. So in those cases, if there is no commission being offered, or if it's less than whatever I stated in here, then I may come back to you and go, do you want to pay the difference for me to represent you? Or do you want to release me from this so you can pursue it on your own or with an attorney or just going direct to the seller? So if the seller isn't offering money, or isn't offering compensation, you have some options to either let me out of this contract and work on it on your own, or work out an agreement where I can try to negotiate more compensation from the seller who's not offering any, or from you, and we can make the decision at that time. And then that's it. I'm done. And this is within 30 days. If within 30 days after the expiration, remember we listed the 15th of July for this expiration. Let's say we get into a contract on July 15th or 16th. I'm still your guy. I'm still your agent. I'm still working with you. If we looked at homes during that period of time and you decide then you don't want to purchase one, but you do later, and you have not started working with another agent, all the terms of this agreement apply within 30 days. Paragraph 9 is a relocation program. If you're relocating, then we would fill out this information. If you're not, we're going to hit no. And this should be a trigger. You don't have to sit there and go, are you a member of USAA or Navy Fed or any of those? Just ask them if they're aware they have relocation benefits. If they do, list them in here and then act accordingly to respond to it. Paragraph 10, this is a disclosure that we're going to be representing you, and that you should know the seller is represented by their own representation. The buyer, that's me, buyer agent, will be representing you. And then designated representation is in the cases where maybe I'm representing you as the buyer, but our firm has the listing, then that would be designated. The broker is allowing the two of us to work together. Just understand we're both working the same company, and I will tell you when that comes up as we go into each home. Dual representation, it is perfectly lawful in the Commonwealth of Virginia for an agent to work with both buyer and seller. Understanding that the trade-off for that is that you get fewer services. I'm not allowed to do anything if I were in that situation that would put you a higher point of better position than I would the seller. And so you have to give up some of those things that we talked about earlier. Lucky for you, I don't personally do dual agency. I will only represent you. If it is my listing, we can go look at it. If you want to make an offer, I will find someone to represent either you or the seller to make sure you have your own guidance and advice and representation. Now, if you, the agent, actually do dual agency, then you're going to have a different conversation and just explain that, yes, I may be able to represent you and the seller, and there are certain skill sets that I cannot provide to you at that point. I may have already talked to the seller about this. Let me show you the dual agency form. And remember, in the dual agency form, there's 5 elements you're obligated to disclose and have them sign, saying they understand that they're getting lesser service and paying the same amount of money. So that's how you disclose that. And then paragraph 11, Mr. and Mrs. Buyer, everything we do in residential real estate is guided by the fair housing laws. There may be times where you have questions or even comments about things that actually start to tread into the fair housing thing, which is a very broad law. And so you may ask questions about children in the neighborhood or information about families. I can't provide you information or my advice about an area. I will give you a report called an RPR report or CBX that breaks down education levels and income levels and all those non-fair housing things that you can roll through, but I can't help limit areas based on certain attributes. So you're just going to have to understand there's certain things I can't help you with. And this is going to be all federal laws. The Commonwealth of Virginia also protects people who are 55 and older, and the Code of Ethics adds sexual orientation as a protected class. So those are things we do not discuss, and I cannot help you if you have some type of bias and you don't want to live in certain areas because you have issues. I can't facilitate that. I can't help narrow down areas based on your preference for only a Jewish community or a Christian community or something else. Paragraph 12 is a lengthy paragraph with all agreements. There is some legal exposure because we're dealing with agreements, contracts between you and the buyer, my representation of you. This outlines that we can go through arbitration, or if there's any lawsuit, who pays for what regarding representation and purchasing of a home. Paragraph 13, the buyer is or is not a real estate licensee. Paragraph 14 is a few disclosures that are important. First, I am acting only as a real estate licensee. So I am not an attorney or tax advisor. I don't have special skill sets to inspect your environment. However, I do have people who do those services for you and that I can connect you with if the house and situation dictates it. Megan's Law is a federal law that each state has adopted their version of, that it creates a website or a phone number for you to contact should you be concerned about the criminal history of people in the neighborhood. And it's only certain types of criminal history. Crimes against children and sexual offenses are all listed here, and you can research that on your own. Mr. and Mrs. Buyer, you do need to be clear that this website needs to be consulted prior to making an offer. This is not a way to get out of a contract. This is some due diligence you need to show before making an offer. Wire fraud is a big deal, and Mr. and Mrs. Buyer, you should understand that we are a huge target in our industry. We deal with lots of money coming through, lots of personal information, and we have lots of data passing online back and forth, and even writing and written records. And so if you get anything that looks suspect, anyone who's asking for your personal information or wire instructions or financial information or anything that doesn't seem normal, please consult with me before you click a button, before you respond to the email. If I'm asking for personal information, I will give you a heads up before I send the email asking for it, or before the settlement company sends an email to you. Do not respond to anything or click anything until we have had a conversation. Also, the service provider referrals. This is derived from the negligent referral lawsuits that I've been talking to you all about for 10 years now. And this is to say, Mr. and Mrs. Buyer, I'm going to refer service providers to you, contractors, inspectors, all those folks, but I can't always warranty them or their quality of their work. You're not obligated to work with the people I refer in order to work with me, and you should always research your own folks. I'll give you some suggestions, but it's up to you whether you choose them or not. And then lastly, in paragraph 15, this agreement is a written agreement. Any changes need to be in writing. Sometimes it'll be by email, sometimes it'll be a formal addendum, but whatever we need to change will be in there. And then we ask that if you are going to visit any new homes, open houses, new construction, whatever, please let me know before you go in there. And by the way, here's a stack of business cards for you to carry with you. If you do enter new construction or all that, you need your own representation and a consultation. That's me. Give them my card when you enter the home so they know you're being represented, and can call me if you have any questions. And after that, we need signatures, and then we can go look at homes. That's it. That's the buyer agency agreement. If you have any questions, feel free to reach out to your brokers. They're well versed in this agreement, and I'll be around to help you however I can. Thanks so much for listening.